The clerk will call the roll. If you're here, vote aye. If you're not here...
Senator Norman, I have you registered as aye. Is that correct? Okay. Mr. Chairman, you have a quorum.
Okay.
I'm here, sir.
Okay, thank you. We have a subcommittee report from Senator Peterson.
Yes, sir.
Okay, you got three bills. Is that according
Yes,
to
sir.
my
And
records?
let me get right to it.
Okay.
We had 3 bills in our subcommittee which met. Was it Monday night? Boy, it seems like
Monday afternoon.
seems like an era ago. Okay.
From 4 to 8.
The first bill had to do Senate Bill 1107, had to do with medical malpractice and repealing the cap on med mal. Currently, the cap is at $2.5 million. It goes up $50,000 a year. We had a lot of testimony from both sides. Obviously, the medical society and the medical community likes the cap and wants to keep the current situation. We heard from jurors in a case, as well as the husband of a woman who is very tragically and permanently disabled as a result of a botched surgery, and her life care plan, I believe, was $9.8 million in that ballpark. So we had a pretty intense discussion on it, and it was the decision of the committee to not go forward, to PBI the bill. I believe it was a 4-2 vote. I'm doing this based on memory, but I think that's correct. We did feel it's important that this issue is not going to go away. We need to come up with something like the birth injury fund to deal with those catastrophic cases where the life care plan is exponentially greater than what the cap is. Otherwise, it's just going to go to DMAS. But that was our decision in terms of just the straight out vote. It was 4-2 to PBI the bill, and I so move.
Mr. Chairman,
Who's
speak to the motion. Stanley,
Senator Stanley, yes.
Mr. Chairman, this medical malpractice bill started out as elimination of the cap, but then was just a safety valve, which only addressed what we believe to be the most catastrophic injuries suffered at the hands of clear malpractice that would have allowed for economic damages to be paid in excess of the cap. I understand the subcommittee's recommendation. I was there. I want to thank the chairman of that subcommittee for an excellent job in handling this issue, and also on how he handled the witnesses as well. I will tell the chairman that subsequent to the subcommittee's meeting, some of the stakeholders reached out to me on the other side and said that they understood that this was an issue that needed to be addressed and looked at to see what we could do to take care of those very rare cases, those catastrophic rare cases like Nancy's. And so, Mr. Chairman, I understand that the vote now on the floor on this motion is to pass it by indefinitely. But I'd ask if the chair would consider sending this bill to the Boyd Graves Commission and see for further study while we try to work something out over the summer. Thank you, Mr. Chairman.
Okay. All right, so the motion is to pass the bill by indefinitely. That's the recommendation of the subcommittee, and if we do that, then I will send a letter to the Boyd Graves Conference, okay? All in favor of the motion to pass the bill by indefinitely, vote aye.
Senator Norman, how do you wish to vote?
Senator Norman votes aye.
Ayes 12, noes 2.
Okay, thank you. Ayes 12, noes 2. The bill has been passed by indefinitely. I'll send a letter to the Boyd Graves Conference to study it further.
Mr. Chairman.
Thank you, Mr. Chairman.
You don't know who Boyd Graves is? Money Boyd, Munford Boyd, used to be a professor at UVA Law School. I knew him quite well. I don't know who the other guy is, though. Go ahead. All right, Senator Peterson.
Chairman.
Yes.
Okay.
Senator Norman.
Yeah, Senator Norman.
Just very briefly, I know you're going to send the letter to Boyd Graves, and for some reason I could not get into the civil subcommittee because we were doing other things on finance. My issue on this bill is very narrow, and I just wanted you to be reminded of it when you send the letter. In 2012, a deal was worked out between all of the parties. Senator Saslaw and myself were very involved in it, and we came to an understanding we came to an accord, if you will, that the med malpractice cap would not be adjusted for many, many years. And that was the genesis of the compromise, except for the $50,000 annual increase on it. And we can look at some collateral sources, but I just think we need to be respectful of the understanding that was reached by all of the
All right,
parties. Thank you, Mr.
Yeah,
Chairman.
thank you, appreciate it. Okay, the next bill is Senator Peterson.
Yes, sir. So, Mr. Chairman, the next bill is Senate Bill 1209, and this bill I know has gotten attention both from the labor and the business community. It has to do with the liability of general contractors when a subcontractor fails to pay wages or otherwise violates the Minimum Wage Act or the Fair Labor Standards Act. This was part of legislation we had last year, I believe from Senator Eben, that dealt with wage theft. And as part of that, we added the statute we have right now, 11-4.6, which was liability of the contractor for wages of subcontractors' employees, which effectively means as a general contractor, you could pay a sub, for example, to put on a roof, to put on windows, to do the HVAC. You write the check for the sub, you fulfill the contract. It turns out later the sub had not paid their own employees or hadn't paid them properly, and now you'd turn out to become liable for all of the penalties, I believe including attorney's fees. So needless to say, this raised a lot of consternation in the construction industry. I had people come to me and ask if they could have guidance or at least some type of relief from this. I do note that in the bill we passed last year, and I remember the negotiations on this, there's already, it says that the section applies if the general contractor knew or should have known that the subcontractor was not paying all wages due. And what my bill does is basically adds what essentially would be an element of evidence in that, which would be a signed certification by the sub that he has paid his employees. So basically, as a general contractor, when you make the payment to the sub, you're getting back some type of signed certification from them that they've complied with the law. Mr. Chair, you suggested an amendment which was adopted by our committee. So what I'd like to do is ask that be reported, and then we'll make that motion.
Okay.
John, do you have that language?
I don't.
Mr. Chairman,
I mean, I'm talking, yes, staff.
Yeah.
If staff could report the
online-
amendment.
on line 44, after 500,000, it shall be a valid defense if the general contractor obtains a written certification, and insert as evidence a general contractor may offer a written certification, comma, under oath, comma.
So basically what we have here is changing it from it shall be a valid defense to it shall be evidence. So it's not conclusive evidence. It can be rebutted like any other piece of evidence, but just simply saying that this is record keeping, just like we do a criminal background check for private sales now. This is record keeping that you could use to protect yourself. So that was the bill. The opposition was from the labor community. They had concerns about subcontractors not paying their employees and gave examples of that, and basically stated that the general contractors are in the best position to avoid this, and they can require indemnity bonds potentially. Now, we had some back and forth about whether indemnity bonds were available and how much cost that would add to construction projects, but that was sort of the gist of our conversation. The bill passed out on a close vote. I believe it was 3, 2, and 1 abstention. I was one of the ones in favor. It's my bill, and so I move that it be reported.
Okay.
Yeah, we have to adopt the amendment.
Yeah, adopt the amendment. It's been moved and seconded that the amendment be adopted. Okay. Now, you have the motion to report the bill as amended. Senator Peterson's motion. All in favor? All right, ready? All in favor?
Mr. Chairman?
Yes, go ahead.
Sorry, I had a quick question.
Senator
I
Sherrill.
don't think this came up in the committee, and I don't think Senator Peterson just mentioned it, but one of the things the bill also seems to do, lines 18 and 19, is it takes the suppliers of materials completely outside of the bill 100%. And was that also part of your intent? I mean, that would be it would carve them out of the policy we enacted last session.
Right, and I think that would make sense because let's say somebody brings a pallet of bricks to the work site to say that you now have to be responsible for that person who brought the pallet of bricks as to whether or not they paid their truck drivers. I don't think that was the intent of the bill. So I think that's more claritory, to use the gentleman from Bath's position.
Okay. All right, it's been moved and seconded that the bill as amended be reported. All in favor of the motion, vote aye. All opposed, vote no.
Senator Norman, how do you wish to vote? Senator Norman?
Senator Norman votes no, sorry.
It will be so recorded. Ayes 11, noes 4.
Okay, the motion carries
All right.
11 to 4.
That Boy Scout McClellan Norman coalition strikes again. All right. The women and Tommy. All right.
Okay. The next, Senator Peterson.
Yes, sir. Mr. Chair, the last one is Senate Bill 1435. This is Senator Hanger's bill dealing with the electronic execution of estate planning documents. And I have to say, we heard a lot of testimony. Lane Needler wanted to call in and somehow did not get an opportunity. And I know time is short, but considering the high regard we hold Lane, Mr. Chair, would it be okay if he could testify?
Yes, if he's here, he sent me an email, and I apologize for not getting back to him. He's in Santa Fe, New Mexico, 2 hours away, I guess. And if he is available, be nice to hear from him, because he's a great friend. I've known him since law school days. He's an esteemed attorney. He used to be Chief Deputy Attorney General of Virginia. Is he around? I don't know.
Yes, Mr. Chair, he's in the room right now.
Oh, terrific, great. Lane Needler, great to see you, I think, at least to hear from you. Thank you very much.
Mr. Chairman,
Yes,
can you hear me?
yes, we certainly can, Lane.
Okay, thank you, Mr. Chairman, members of the committee. Thank you for this opportunity to speak. I'm here on behalf of the Uniform Law Commission, of which I am a 30-plus year member or representative from Virginia to the commission, which, as you know, is a highly respected national law reform group that works closely with the American Bar Association. The commission is composed of about 350 commissioners from all 50 states, Puerto Rico, and the Virgin Islands, about 60% of which are, oh, wait a minute, can you see me?
No, we can hear you.
Sorry, it's not a very good view anyway. Oh, there I am. Oh, I just did it. Okay, it's about 60% practitioners, 20% judges, and 20% law professors. And a number of the members are members of their legislative chamber in their jurisdiction. Uniform acts are adopted after a very rigorous, inclusive, thorough, deliberative process. It works like this. There's generally a 1 to 2 year study of the idea before the commission decides to go forward. This was a 1 year study and they decided yes. The executive committee then has to decide whether to go forward. They did. And a drafting committee was appointed, which consists of about 10 to 12 commissioners. And then stakeholders are asked to participate as well. And imagine if we did this process here in Virginia. The drafting committees will meet at least 2 weekends a year for 2 years. And those weekends are all day Friday, all day Saturday, and often a half day Sunday. And I've participated in a lot of them. It's a policy wonk. I think it's fun. But then, as former Speaker Philpott would have said, Lane, you're crazy. Anyway, I enjoy it. And in between, there are conference calls where things are also worked out. After the first year, it goes to the full conference, like the Senate floor. And the bills are debated.
Mr. Chair, I think maybe we could tell Mr. Needler to just talk about the bill, please.
Okay, no, I'm not the expert on the bill. I just wanted to assure you that this went through a very thorough 2-year process and was then adopted with one vote by state, by all states and territories except Puerto Rico, which doesn't attend the annual meeting anymore.
Thank you.
Very thorough.
Thank you, Lane.
Thank you, Lane. Appreciate it.
Thank
very
you.
much.
All right, thank
I
you.
appreciate the permission.
Thank you very much.
Mr. Chair, let me just cut to the chase. We tied 3-3 on this, and I voted for it. I think there was some concern about documents being notarized when people were not in the room, and attorneys preparing documents for people who were not physically present, and whether or not there might be a case of undue influence. And I see my expert reaching for his microphone and preparing to speak, so I would probably defer to Senator Obenshain to have a comment.
Senator Obenshain.
Just real quickly, a couple of the concerns are, first of all, this is not the bill drafted by the Uniform Commissioners. It is a bill based upon that. 2 states have adopted the Uniform Act so far. That's it, 2 states. We traditionally wait a little bit longer. The concerns about this particular bill are, number one, that were discussed in the meeting were, number one, these electronic wills do not have to be drafted by attorneys. They do not have to be drafted by attorneys. Nobody has to be in the room with the testator. So the witnesses are not there with the testator. The notary is not in the room with the testator, and there's no way of telling whether somebody else is in the room with the testator. So in a period of time in which we are concerned about elders being isolated and alone and being victimized by others like a family member or a caregiver, there's no way of telling whether that person is somehow asserting influence causing the person to do the will. That was the concern. The folks from the Wills Trust and Estate section did a very good job of explaining that to the extent that they could, they inserted as many safeguards as they could, but those were issues that were not intended to be addressed by the bill.
Okay. Any other discussion?
Mr. Chair,
Senator Deeds.
I think the bill raises some issues that need to be addressed. In this time of pandemic, when social distancing has been the desired norm, the execution of certain estate documents has been difficult, to say the least. And it concerns me that this bill is based on a model, but our uniform model, but not the uniform bill. And I would suggest that if we do not pass this bill, this is a prime candidate to ask the Boyd Graves Commission to look at and report back to us.
Mr. Chairman.
Senator Sherrill.
Thanks, Mr. Chairman. I think I was one of the ones that voted no, and there was a couple things I struggled with. One was that it is a uniform act, but I believe it's only been adopted in 2 states. It's a brand new uniform act. It's being proposed, I think, in 3 others, but it's brand new, number one. Number two, one of the concerns that I continue to have is, as we do this electronic stuff that carries legal impact or import, I never know who's on the other side of the computer. I mean, you can see on the camera who you're talking to and who's there, but you can't see who else is in the room. And I mentioned in the meeting that I've had depositions where, it was actually trial testimony. I was trying a 4-day divorce case, and this witness was sitting there talking while the microphone went on and off, and his son happened to be in the room but wasn't on screen, and I couldn't see that was happening until I finally saw the mic going on and off and said, "Is there anybody in the room with you?" "Oh, yeah, my son's right here." And who knows if the guy was holding up cue cards or hitting buttons or telling him what to say or whatever. And it wasn't really clear to me exactly how this act addressed that. When you're talking about somebody, executing a will, disposing of potentially millions of dollars, I just didn't quite have an answer for that. And I guess the response they gave was, well, somebody could still do some hijinks on a paper will or something. And it's one half dozen the other was kind of the response, but I was just kind of uncomfortable with it. And that's why I voted no.
Okay, anybody else?
Mr. Chairman?
Have any questions? Who's this, Senator Morsi?
Yes. I'd just like to ask the patron, and I'm sorry I don't know the answer to this, I should. When you're talking about the will must be signed by two witnesses who are in the physical or electronic presence of the testator, tell me exactly what you mean when you say or Senator Peterson, what you mean by the electronic presence of the testator.
I think that would mean, and if I'm incorrect, Emma can correct me, that say, for example, you're on a Zoom call or some other call where you can see the other person actually execute the document. I can physically through FaceTime or what have you, but through some app, you can see them actually execute the document.
Okay. Anybody else? I have the same concerns the senator from Rockingham's articulated, not being in the room and so forth. And I think it makes sense to have the Boyd Graves Conference yet again study this.
Mr. Chairman?
Yes, Kristen.
There was a substitute that Senator Hanger wanted, and if you're going to send it somewhere, it might be good to have it in the proper form. It addressed the clerk's concerns about having a certified copy of the e-will before they would probate the bill. So
I'll make a motion to adapt the substitute. I do note, Mr. Chair, that Senator Hanger's here and striding to the podium with alacrity.
Senator Hanger, front and center.
What did you say, with alacrity? Oh, sorry.
And do you practice
yes,
this type of law?
I don't want to prolong this. I'm not a lawyer. I will say, though, that I've been the executor for an estate 4 times, and I buried a friend last weekend. I'm going to appear in Augusta Court Friday afternoon to hopefully qualify for the 5th one.
Oh, that's good enough.
Now, having said that, I am not a lawyer, but I do understand the logistics of qualifying and what we're talking about here as electronic signatures on it. I would also share that the Virginia Bar Association has been working on this a couple years, and they have taken the Uniform Act and basically tailored it to Virginia. They also, I met with some of the clerks of the court before coming down here, and some of the concerns that they shared are embodied also in the substitute. So I'm not saying it's a perfect document. I'm saying that I think a lot of work has gone into it, and so I felt the need to step forward so I wouldn't prejudice against Delegate Sullivan, because I think he's going to roll his over here, and I know y'all might follow precedent if mine fails.
Okay. Okay, thank you. Any further comments? Is there a motion? Somebody want to move the report? Who's that?
First you had the question of the substitute.
We haven't done the substitute yet, Mr.
Adopt the substitute. Is there a motion to adopt the substitute? I don't have it in front of me. Okay, second. All in favor of the motion to adopt the substitute, say aye. Aye, okay. Now, does anybody want to pass the bill by indefinitely and send it to the Boyd Graves Conference?
I would.
Yeah, Senator Oberstein.
The only thing I would suggest is if you're going to send it somewhere, I'm not sure that the Boyd Graves Conference is the best place. That's plaintiffs and defense lawyers. It's primarily litigators. Maybe to the VBA and ask them to look at it.
To the Virginia
and
Bar
send it to the right place.
Let's see, send the Virginia
Maybe
Bar
the same place it came from.
Yeah, trusts and estates, wills, trusts and estates section, I believe is what they call it. Should we do that? Okay.
Mr. Chairman?
Yes, Senator Serval.
I mean, I've been having this go-round with the trust and estates folks now since this pandemic hit. I mean, when this all blew up and the orders came down, and the executive orders, they were all banging on the Supreme Court to try and get the Supreme Court to issue some kind of an order.
So what do you want to do?
And just hold on a second. My point is that this proposal comes from the lawyers who write wills, and we're going to send it right back to the same people who are going to come back to us and tell us to do it. And I think it's the people who don't write wills, the ones that have concerns. And so I think Boyd Graves might be the right place to send it, because they're not people that make a lot of money from being able to do this and want to get this done as efficiently as possible. So,
where did you get it, Senator Hanger? Where did it come from? Where did it come to you? Who gave it to you? Okay, all right. Okay, is there a motion that we pass it by indefinitely and send it to who?
We beat you out of the bill with the chairman sent a letter to the Boyd Graves Commission asking them to take a look at this and report back to us by the beginning of the next session.
All right. Second. Moved and seconded that we pass the bill by indefinitely and have the Boyd Graves Conference take a look at it and give us a recommendation. All in favor of the motion, say aye. Yeah, vote aye.
Senator Norman, how do you wish to vote?
Senator Norman votes aye.
Ayes 15-0.
That's 15-0.
And Mr.
Thank you, Senator
Mr.
Hanger.
Chair, that is our complete report.
Okay, thank you. Now we have Senator Lucas and Senator McClellan. Who wants to go first? Senator Lucas, alphabetically.
Which bill do you have for me?
You have a bill.
Which bill do you have,
We
sir?
had two bills sent to us from Finance today, didn't we?
Yes, two bills from Finance.
Okay.
Senator Lucas.
You want to go first while I find mine?
Okay, Senator McClellan is Senate Bill 1360. Senator McClellan.
Thank you,
This has to do with Virginia Human Rights Act.
Yes, Senate Bill 1360 is a bill that was heard by General Laws that is supposed to do two things. It was intended to provide a clear definition of workplace harassment and sexual harassment in the Human Rights Act. It did not create, those are already covered by the Human Rights Act, but there's no definition. And so the bill puts a definition in the code, and it was intended to put some parameters around things that could be considered to determine whether something meets the definition of harassment. It was not intended to address liability, because that would be determined by state and probably looking to federal case law. This was not supposed to be a liability bill. It also fixed some confusion left by amendments to the Human Rights Act last year by making the statute of limitations for a complaint to the Attorney General's office be consistent for all claims under the Human Rights Act. Those two pieces of the bill are not controversial. While not everybody was wild about the statute of limitations piece, that's not where the controversy was. Over time, based on some activities in the other body and concerns raised by the business community, the chamber wanted some parameters around liability put into this bill, and we have attempted, the coalition supporting this bill that represents mostly workers and employee lawyers, and the lawyers representing the business community have been negotiating for about 3 or 4 days on liability. We are very close, but we have two competing substitutes. And rather than trying to sort that out in the Finance Committee, we decided to bring that to the Judiciary Committee. I have one substitute. Senator Peterson has another.
No, I don't.
You don't? One was.
I mean, Mr. Chair, I've got some questions, and I have talked to one of the lobbyists, but I don't.
Okay.
I'm not involved in this.
Okay. Well, there was a line. Okay. That's misinformation. There was a line amendment that I understood was being submitted to you to submit. I'm glad to put both before the
I don't
committee
want
and
to
let
put
the
it in.
committee decide between the two.
I just want this bill to go away.
Charles, do you have the line amendment that Connor drafted in addition to the substitute?
Mr. Chair, I have a substitute for Judiciary, and then I have some line amendments that I could also, the substitute is posted. I could also post some line amendments, and the line amendments are drafted to the substitute that. So I could post both of them right now.
Okay, does somebody want to speak in favor of the bill?
I can't hear you, Mr. Chair.
Somebody want to speak in favor of the bill? I mean, do we have something here to work with?
Mr. Chair?
Yeah, Senator Peterson.
I mean, I'm looking at the definitions of sexual harassment and workplace harassment, and it talks about unreasonably altering the terms. Basically, any conduct that unreasonably alters an individual's terms, conditions, or privileges of employment.
Okay, are you looking at the committee substitute, the one?
I just opened up the substitute.
Okay.
And I guess my question would be, I mean, my wife and I own a small business, and for example, she may buy groceries for the business, and then she may, like when we move furniture around, ask the men in the office to move the furniture for her. Is that was that workplace harassment?
No. Mr. Chair.
You say no right off the bat, but she's asking the men and not the women to do it.
Yeah, Senator McClellan.
Workplace, so if Helen Hardeman is on the line, who is the attorney in the Attorney General's office, who handles these cases.
Well,
Wait, let me finish.
All right.
Go ahead.
The definitions in this bill on lines 42 through 53 are definitions of workplace and sexual harassment that come from federal law, from federal case law. There's already a body of work of law that if you engage in this activity, that is sexual harassment or workplace harassment.
Okay, well, that being, and I respect that, but I guess the question then becomes, I don't need to talk to the Attorney General's office, because one, they don't own businesses, and two,
Well, is there somebody that would like to speak?
Mr. Chair.
Yeah, Senator McClellan.
Sexual harassment would be, it's not just do you ask the men to do something and not the women. It is, are you a boss or a supervisor who engages in conduct on the basis of sex that unreasonably alters your employees' terms, conditions, or privileges of employment, including by creating intimidating.
and I just gave you an example of that.
If you ask someone to move furniture,
That's
if
not-
you say, move my furniture, or if you say, sleep with me, or I'm going to fire you, that's sexual harassment.
No,
If
Jack-
you say, move this furniture because you're a man and I'm a woman, that is not sexual harassment.
But Mr. Chair,
That's not what your language
Mr.
says.
Chair.
Is there somebody from the Attorney General's office or from the public who want to say anything about the bill? Yeah, somebody?
Mr. Chair, can I ask a question?
Yeah, Senator Deeds.
Yeah, but Senator McClellan, look down on lines 48 the following. Workplace harassment means conduct on the basis of sex, regardless of whether it's direct or indirect or verbal or nonverbal, that unreasonably alters an individual's terms. Using terms, conditions of employment, using Senator Peterson's example, if I ask a male employee, the male employees, exclusive of the female employees, to move furniture, have I unreasonably altered their terms of employment?
You haven't altered their terms of employment at all.
Of course you have.
You made a request.
They're hired to be lawyers or paralegals or secretaries. All of a sudden, I'm asking them to move furniture.
Mr. Chair,
Yes,
why
yes.
don't we have,
Senator McClellan, go ahead. Go ahead.
Workplace harassment.
Let's one at a time.
Two
Senator
different
McClellan
definitions.
is trying to explain it. Go ahead. Senator McClellan, go ahead.
I would like, if Helen Hardeman is on the phone,
Okay.
is Helen Hardeman on?
From the Attorney General's office?
No, Mr. Chair. They
Okay.
do not appear to be on.
Okay, Helen Hardman.
We don't have anyone signed up to speak with that name.
Okay, who do we have to speak? Anybody?
At this time, no hands are raised, Mr. Chair.
Okay, Senator McClellan? What do you want to do about the bill?
Mr. Chair.
Yeah, go ahead.
I mean, if
Mr.
we are
Chairman,
going
I
to
have a
get,
question of-
like, this is not even this part of the bill is not even in controversy.
Okay.
So I'm a little,
What do we need to do? You have the floor, Senator McClellan.
Mr. Chair, if this could go by temporarily for me to get Helen Hardeman on the line to answer Senator Peterson's question.
Okay.
Because clearly he does not believe what I say.
Senator Peterson.
Mr. Chair, I do believe what Senator McClellan says, but I also believe that the words in the statute actually have meaning. And I've litigated Title VII cases. Okay, I've been in a federal court litigating them to a jury, so I don't need to be lectured about what these cases mean.
I've done the same thing, Senator Peterson.
Yeah.
So I guess we need a little bit of time. How much time do we have? Going back to Senator Louise Lucas, do we know what the bill is? There's some bill.
I don't have any bills in this committee this afternoon. There's nothing here.
I thought that was a
Mr.
bill.
Chairman, the only bill we got
only
from
bill
Senate
we
Finance
referred
this
to
morning was
Judiciary
Senator
from
McClellan's
Finance.
bill.
Okay. First of all, Senator Louise Lucas, there's a bill that was referred to us from finance. I don't know what the bill is. Does anybody know?
Mr. Chairman, we don't have any other bills in our committee besides
Okay.
Senator McClellan's bill.
Okay. All right. Back to Senator McClellan. Where are we now?
I know I didn't have anything.
Mr. Chairman, I'm with Senator Saslaw. Something was said by the clerk who felt that it was important, but I couldn't understand a word.
Mr. Chairman,
Yes.
I was saying the same thing that Ms. Waltz said.
Okay. All right. Going back to Senator McClellan's bill. That's the only bill we
Mr.
have
Chairman,
before us,
I had a-
apparently. Yeah.
Mr. Chairman, I have a
Norman.
question.
Yes.
Senator.
Go ahead.
Senator McClellan, I'm thinking in the terms of a law practice that I have, and I'm an outlier in a very large law.
They would do it.
And out of 100 lawyers, I'm the only one that practices criminal law, but I do it for the entire firm. My question is, if I get a sexual molestation case and I say to one of the paralegals, I want you to work on this case, and that paralegal says, I can't do that, I am offended by that, and I don't do that kind of work, does that put me in a difficult position under your bill?
No, Mr. Chairman, it does not.
Mr. Chairman, why?
Mr. Chair, Andrea Johnson is on the line who can answer that question.
Okay. Thank you. Ms. Johnson.
Thank you. Andrea Johnson with the National Women's Law Center. So this language that unreasonably alters the terms, conditions, privileges of employment is really important controlling language that's used in federal law. It's taken from federal law to make it so not just any conduct constitutes workplace harassment. It needs to impact the job, and it also needs to be based on a protected class. What this bill is trying to do is to avoid situations where we have courts that have found that the fact that a woman is groped, her breast is groped, is not sufficiently severe or pervasive to be workplace harassment. Those kind of cases are being thrown out, and I think we can all agree that that is workplace harassment and is not something we want courts to throw them out. But right now they are throwing it out because it just happened once. That is what the bill is trying to get at, that kind of egregious conduct not being perceived as harassment. But the language is in there to provide this clear and safe barrier that needs to unreasonably alter the terms, conditions, privileges of employment. So it's not just anything that would constitute harassment.
Senator Peterson.
Let me ask this witness a question. You just talked about a woman who is groped. First of all, wouldn't she have an assault claim?
She could have an assault claim as well, but there are really important protections under civil rights law as well. And there are cases too where the N-word is repeatedly used against.
Okay, well, hold on. Let me ask a follow-up question. Why would she not have a claim to the EEOC? Why would she not have a Title VII claim? I mean, there's already 60 years of federal case law and Title VII claims. Why, I guess what I'm saying is, why would that not qualify as a federal cause of action? Or is the point of this bill to capture those claims that don't rise to the level of a federal cause of action and therefore create basically a supplemental cause of action when it's not, for lack of a word, big enough for the federal courts?
So the example I gave is an example that should rise to the level of harassment under federal law and under the Virginia law. Unfortunately, there's confusion amongst courts because it's not clearly codified in federal law what the definition is, what the standard is. And so you have a lot of varying interpretations, some of which involve courts looking at something like a woman's breast being groped by her supervisor and saying, well, it happened just once, and throwing the case out. And so we want to make clear that that it's consistent in Virginia law, what the interpretations are, and it's clear, and those bad cases don't get thrown out.
Okay, well, hold on a second. So what you're saying is that federal case law is not clear enough, but this isn't going to change federal case law.
This is, right now, Virginia's Human Rights Act looks very similar to federal law, uses very similar terminology. And so we want to make sure that the Virginia law does not adopt the confusion and problems that have arisen under federal law.
So basically, to sort of summarize, you want to make our law better than the federal law because the federal case law is not favorable enough from your perspective.
We want to make it clear to what it intended, the federal law intended. The EEOC has made very clear that this is what was intended originally, but through time, Courts have, some courts, not all of them, but some courts have gone off track. And we want to make sure that we don't have that, that there's clarity in Virginia law. What this is pulling from is federal law, and making clear that we don't have these kind of off the wall situations arising.
All right, thanks.
Mr. Chairman.
Yeah, Senator, who's this?
Morrissey.
Morrissey, okay. Senator Morrissey.
To the lady who was just speaking, I'm sorry, I didn't get your name.
Hardeman.
There is a difference, is there not, between workplace harassment and sexual harassment?
Workplace harassment and sexual harassment is a form of harassment. Workplace harassment is just a term used to recognize that there can be harassment based on race, based on national origin, based on sex. Sexual harassment is just one of those forms.
Well, further question.
Yes,
I'm looking at line 52, and it says workplace harassment includes sexual harassment. So would it be a fair statement that workplace harassment is more expansive than sexual harassment?
No, it's only insofar as sexual harassment, as it reads, deals only with sex, whereas workplace harassment, it's the same conduct as sexual harassment, but involving other protected classes.
Further question. I'm looking at page 7, and I have the substitute in front of me now. And beginning in line 169, it says 3 factors in determining whether conduct constitutes workplace harassment include, and then you go down to 9. Do you see that? Can you tell me whether the conduct reflects stereotypes about individuals in the protected class, and whether you think, and whether it's possible that might just be a little too vague?
So these are factors that, again, are pulled from federal law. These are purely permissive factors and the AG's office has said this in their testimony previously, that these are helpful factors for courts to look to better understand what they need to do, to consider in evaluating the case. It's not saying that if something, meets one of the factors that makes it harassment. It's just things to look at, because courts have had challenges with kind of knowing what to look at, the full body of evidence and factors to look at. And this is just providing things they can look at. None of them are dispositive, determinative at all. It's just, saying things like stereotypes could be relevant. Yes, and I see that Helen Hardeman from the AG's office is also on the line now as well.
Okay.
One final question, Mr. Chair.
Senator Morrissey.
And I'm just trying to drill it down, because we don't want to include conduct when we read the language of a statute that we don't want to capture. But Senator Peterson gave the example of the furniture. He asked the man to move the furniture because maybe he's stronger. I don't know. Is it workplace harassment if I ask the woman in the office to get me my iced tea, and I never ask a male to get the iced tea? Would I be exposed to a workplace harassment based on the factors set forth in paragraph 3?
That is for judges to determine. I think it needs to unreasonably alter the terms, conditions, privileges of employment, which is, a high standard, so that not just anything would qualify. Maybe there would be a case for disparate treatment there, but
I understand.
It sounds like what you're saying. These are already factors that case law has indicated that can be used.
Mr. Chairman?
Is that right?
No,
Let
Mr.
me get the
Chairman.
answer. Is that right? Is that right?
Yes, these factors are pulled from federal case law.
Okay.
Mr. Chairman?
Yeah, Senator
Suravel, thanks. I got a question for the witness.
Go ahead.
Okay, so I've got a law firm with, 35 employees, something like that. And I have some associates, people who are not owners. They're lawyers that work there. They supervise some secretary or two. They supervise a paralegal. Hypothetically speaking, if I had an associate who was asking for sexual favors from a secretary, and nobody in the firm knew about it besides those two people, and nobody brought it up or said anything to anybody about it, and we have a policy, we have a written policy saying you can't do that. Wouldn't you agree that under federal law, that the law firm, the company, the owners, would not have any liability for that at that point? Under federal law, not this law, federal law.
Go ahead. Go ahead.
I don't know if you would like me or Helen Hardeman, who to speak
I
to
think
that.
you.
Okay.
I think question to you. Go ahead.
I'm sorry, I missed the beginning of the hypothetical. Did it involve a supervisor?
It involved an associate asking for sexual favors from their secretary or, say, a paralegal that they supervise and work with.
So the standard that is in the substitute that that Senator McClellan has offered addresses liability in that context, and it's the employer needs to know or should have known about it and failed to take corrective action.
Thank you, Mr. Chairman.
Yes,
Follow up.
we got to move this along. Go ahead.
But wouldn't you agree that under this law, there's no requirement that the law firm, the managers, the owners, whatever, have knowledge? And so under this law, the associate could be doing this thing, asking the secretary, the paralegal for sexual favors. The owners, the supervisors have no idea. But under this law, the business, not the associate, but the business as well, would have liability.
So this law, if you're talking about the bill that the substitute that the
Correct.
senator has introduced, does not change liability from federal law. It is the same as under federal law.
Okay.
Nothing is changing there.
All right, let's move on. Helen Hardeman from the Attorney General's office. Go
Yes,
ahead.
Mr. Chair.
Yeah, go ahead.
I apologize for being late.
It's okay.
I can probably try to address a couple of hypotheticals, although there are, as my fellow attorneys know, a million possible hypotheticals to consider. Senator Morrissey, I don't think that what you described about asking a female employee to bring you iced tea is going to rise to the level of harassment. I worked on a case at the Office of Civil Rights here at the OAG where an employee was alleging various things, but including harassment based on national origin. And some of the evidence that she brought forward and was alleging was that the manager made her clean the break room because he perceived her to be Hispanic. And so he asked her multiple times to clean the break room. He told her, according to her, that Mexicans like to clean, and so she should clean it. There were several other employees who, when she would come back from the weekend, would ask her if she vacationed in Mexico and that she looked darker. I mean, it was a whole host of really sort of inappropriate comments that, in that case, I couldn't prove that any of it was true. But if it was, in a totality of the circumstances, I think that behavior could have amounted to a hostile work environment such that it affected, the terms and conditions of her ability to work there free from discrimination. Asking someone to get iced tea once, probably not. Senator Surivel, if you have an associate in a law firm that has control, for lack of a better term, over a secretary, the ability to make tangible employment decisions about her employment, and I'm just sort of defaulting to the standard gender terms here, forgive me for that, but if he tells her that she has to perform sexual favors in order to gain some benefit like time off or a raise, then if he's considered a supervisor, the employer would have vicarious liability in that instance. Now, if they took reasonable care to prevent that, and if she reported that and they took immediate and prompt corrective action to deal with it, which most decent employers do anyway, that would defeat liability.
Yeah, is this a bill from the Attorney General's asking for it or supporting it or what?
Mr. Chair, the Attorney General's office does support the bill.
Mr. Chair.
Okay. Who's asking? Senator Norbert?
No, Peterson.
Senator Peterson.
And Ms. Hardman, I'm going to ask the same question I asked the lady who testified a bit ago. As I understand this bill, it basically takes the federal standard one step further. In other words, there are essentially federal case law that has not been favorable to plaintiffs, and this sort of cuts through the confusion and takes a more aggressive stance in favor of plaintiffs. It basically is expanding the federal jurisdiction or the federal standards. I would have no problem with having sort of a Virginia companion to the federal standard. But this doesn't seem to be that. It seems to be like the objective is to improve on the federal standard.
Mr. Chair.
Do I misunderstand that?
Mr. Chair.
Senator McClellan or Senator Ms. Hardeman?
Mr. Chair, I would like to answer that question.
Okay, Senator McClellan, go ahead.
I do not believe we have adopted the substitute. The substitute that was presented would essentially do what Senator Peterson just said.
Okay,
However,
Go ahead.
However, there is also an alternative line amendment that was worked on with the attorneys from the chamber that would, if that was adopted, bring in federal law, which Ms. Hardeman can describe that, if that is the preference of the committee to go in that route, which is more to take what elements of federal law that she is the trier of fact for these when they get to the Attorney General's office would have looked to anyway.
Okay, is there a motion to adopt the substitute?
Move to adopt the
No,
substitute.
well,
Have we adopted the substitute?
don't adopt, you need to make a policy decision first.
What do you want to do, Senator McClellan?
I want a bill.
Okay,
So
what
if-
bill do you want?
Mr. Chair, please do not interrupt me.
Go ahead.
If you're concerned, if the concern with the substitute is that you are taking the more favorable elements of federal law and importing them into state law, then you want the substitute. If you prefer to take almost mirror for mirror the federal standard and put it in state law, then you'd want the line amendment.
Well,
We operate by motion.
what about the option of having no bill at all?
Well, we operate by motion. Senator McClellan, it's your bill.
I move to adopt the substitute.
No, the line amendment.
Second.
Is there a motion has been made to adopt the substitute? Any discussion? All in favor of the motion, say aye.
Aye.
All opposed, no? No mo's. Okay, the substitute's adopted. Now we're at a line amendment, I guess. Does anybody want to explain the line amendment or make a
No,
line
you've
amendment?
adopted the substitute,
Yeah,
so
yeah,
now
we
you
just
just have
adopted
the
it.
substitute. So just move to report.
Okay, hold on. What is this? Do we even have the substitute?
It's what you've been looking at.
Yeah. It's online somewhere.
Mr. Chair,
Yeah.
could we have some clarity, because I don't believe we've heard what the line amendment is, and
There's no line amendment at this point. We have a substitute, and that's been adopted. Okay, does somebody want to explain this? Senator McClellan, you want to explain the substitute again, or somebody having more questions about the substitute?
Mr. Chair, I apologize.
Okay, go ahead.
And I know I'm asking, but is the substitute the federal law plus, or is the substitute the mirror of the federal law?
The substitute is those elements of federal law that are stronger for employees. It is federal law, but it is elements of federal law that are stronger to employees.
All right, and I appreciate that. I cannot support this bill, and I think, understand what we're doing here. We are tipping the playing field to favor one side. We've got decades of federal law between employees and employers, and now we're saying, you know what? One side's going to have an advantage because apparently they're not. I think this is a mistake.
Mr. Chair.
Feedback from the business.
All right, okay.
Mr. Chair,
Yes.
having moved to report the substitute, I would like us to reconsider that vote
And I'll
to
second
accept the
that.
substitute.
Already did the second.
Well, I think we're right with the substitute. I
No,
think-
Mr.
I
Chair,
think-
I'd like to consider the substitute.
All right, there's a motion to reconsider the substitute.
So moved.
Second.
All in favor of the motion to reconsider the substitute, say aye.
Aye.
Aye. All opposed, no. So we're back to the original bill.
It's a
Yeah,
recorded vote.
Okay. Back to the original bill.
Senator Norman, how do you wish to vote on reconsideration?
An exhausted eye.
Ayes 15, no zero.
Mr. Chair, I'd like to make a motion to accept the line amendment.
I thought,
second.
let me I thought that Senator McClellan said the line amendment would go to the substitute. No?
Oh,
Okay,
Miss-
all right,
Miss-
fine. All right, I'm sorry. Okay, the line amendment, explain the line amendment, okay.
Mr. Chair,
you
the
had-
line amendment, which is on your screen, the one that is time-stamped 11/51/57. This is language that essentially takes the federal standards from the EEOC guidelines and imports them into the Virginia Values Act for determining liability for workplace or sexual harassment. This is language that, and I believe he's on, I don't know who's on at this point, but that the chamber discussed with the Attorney General's office, and it is in front of you to look at.
Okay, so the
Mr.
line,
Chair?
line amendment was supported by the Attorney General's office. Yeah, Senator Obenchain.
Am I correct in understanding that with this line amendment, that the patron's saying that the chamber supports this bill?
You would have to ask them. My understanding is with this line amendment, they don't oppose it.
Mr. Chairman, Mr. Mullen's on the line, I believe, if you want to ask him.
All right.
I don't. I'm just asking the patron to clarify.
Mr. Mullen, which Mullen?
Edward Mullen.
Yeah, Edward Mullen, okay.
I
Edward
wasn't
Mullen.
asking him.
Edward Mullen, are you on the line?
Yes, sir, Mr. Chairman, I am.
Okay, what's your position, or the chamber's position?
Mr. Chairman, members of the committee, Edward Mullen with Reed Smith representing the Chamber of Commerce. We had several substantive issues with the bill, and when we dug into it deeper, we came upon what I think has been some of the subject of the conversation here, which is the Human Rights Act is really a state-level construct that both mirrors and expands upon conduct protections that have existed for a long time at the federal level and goes beyond them. That was the work last year. And that up until, from the start of the Human Rights Act up until last year, not a whole lot happened under it. But as of last year, because of the legislation that went through that added numerous conduct protections and came up with penalties that are somewhat disparate from federal law, it now will become very important because I think a lot of people will sue pursuant to it. The problem that the sort of bigger problem that we identified when we scratched the surface on this was the issue that while this mirrors the conduct side of the House in terms of prohibited conduct, it does not mirror the decades of federal case law that have developed around when an employer is liable, right? So it imports the conduct, but not the sort of when is the employer on the hook for the conduct that comes in. And so what we did on the House side and what we approached Senator McClellan with was this seems like a really important thing. And if the Commonwealth is to move forward with a workplace harassment piece of legislation, it is mission critical to the business community that the other side of the House, the employer liability side of the House, reflect those decades of federal law. So we worked with the Attorney General's office to come up with black letter treatise language. That is what I think you see in the line amendment, and that sort of boils down the four situational components to, I think, and I'd let the Attorney General's office speak to it if there's a desire for that, the four situations where an employer might be liable. And so we have said to the patron on the House side and on the Senate side that is such a big concern that we will withdraw our objection if an amendment like that is added.
So you support this amendment, is that right? Or the chamber does? Am I correct?
With this amendment, we withdraw objection to the bill.
Okay, all right. Is there a motion to adopt this amendment?
Motion to adopt the amendment.
Second.
All in favor of this amendment, vote aye. Aye. Opposed, no. Call the roll, I don't know. In favor of the amendment, vote aye. Opposed, vote no.
Senator Norman, how do you wish to vote on the amendment?
No.
Ayes 9, no 6.
Ayes 9, no 6. Okay. Anybody else have anything else to say about the bill? The Attorney General or anybody else?
Mr. Chair, all I will say in summary is that workplace and sexual harassment are already illegal under the Virginia Values Act, but there is no definition.
Okay.
This bill will add a definition, and now with the amendment that is consistent with federal law, and now with the amendment describes liability for the employer consistent with federal law.
Okay.
Which is not currently in the Virginia Values Act.
Mr.
Anything
Chair.
else? Yes, Senator Obenchain.
I'm sorry, but I want to know from the Attorney General's office. Is the Attorney General's office still on?
Yes. Go ahead.
Does this amendment require, not just permit, but require federal law to be followed?
Mr. Chair, Senator Obenstein, the amendment is the straight out of federal black letter law for employer liability, such that when someone is alleging harassment,
Does this require federal precedent to be followed?
I can tell you that as a fact finder working on these cases, if I'm enforcing this particular law, that's where I'm going to go to resolve any vague language.
I'm sorry, can you answer yes or no? Does it require federal case law to be followed?
Mr. Chair, there's absolutely no way to answer that question.
Let's see, the answer is she's going to look to the federal law. So, right? Okay. Any further questions?
Mr. Chair.
Are we ready to vote? Could we have, is there a motion?
The bill be reported.
It's been
Second.
moved and second to report the bill as amended. All in favor of the motion, vote aye.
Senator Norman, how do you wish to vote?
I vote no.
Ayes 9, no 6.
As 9, no 6, the bill is reported. Thank you all very much, everybody. Sorry we had to rush it through, but we appreciate everybody's help. I think we finally figured it out. Okay? Without any further ado, the committee will rise.